Thank you, everyone. Justin, I love you on Jane the
Those people died the other night when I was
She's got it.
Hi, besties. So, if you've been wondering what happened with Blake Lively's latest legal filing, here's the tea. Yesterday, she submitted a letter motion to the court basically saying, "I need more time, Judge, and you should deny this motion just because I said so." This was all in connection with Wayfarer's motion for judgment on the pleadings, which is essentially their attempt to wipe out the majority of her entire lawsuit in one go. But here's where it gets interesting. Our favorite scorched earth attorney, Kevin Fritz, has stepped back into the spotlight. And let me tell you, his response to Blake's motion is nothing short of a knockout punch. I was honestly impressed. He doesn't waste a single second. Right from the start, he goes straight for the heart of her arguments and, quite frankly, dismantles them piece by piece. Now, of course, we can't predict how the judge will ultimately rule. Nobody knows for sure. But Kevin has built a strong legal foundation here, and in my opinion, he makes a very compelling plea to the court. He reminds the judge of a critical point. Any party has the right to file for a judgment on the pleadings after the pleadings are officially closed. This type of motion is specifically designed to challenge a plaintiff's failure to state a claim. And importantly, this right is not waived until the close of trial. In simple terms, it means Wayfarer can file this motion at practically any time before the case reaches trial. Meanwhile, Blake's argument is that Wayfarer sat on their motion for nearly 9 months, and that, by filing it now, they're wasting judicial resources and creating duplicative work. But Kevin immediately strikes that down. Remember how I told you that Blake admitted she had to amend her complaint? Well, that's the key issue here. Her operative pleading, the one that actually matters in court, wasn't filed 9 months ago. It was filed just 2 months ago, and only because the court had already dismissed her earlier claims against Jed Wallace and street relations. Here's the thing. Blake wasn't even required to amend her pleadings at that stage. But she chose to do so anyway, filing her second amended complaint on July 30th, 2025. And by doing that, she reset the clock. She knew full well that Wayfarer wouldn't be obligated to file their answers until weeks later. Only after those answers were submitted would Wayfarer even be eligible to file a motion for judgment on the pleadings. That's how the process works. First the answer, then the motion. And it doesn't stop there. Blake even acknowledged this fact herself at a July 30th hearing in a related proceeding. At that hearing, Wayfarer's legal team specifically notified the court that they were considering seeking relief under Rule 12c. So if Blake is suddenly unprepared to respond to this motion now, Kevin argues, and quite rightly so, that the blame lies entirely with her. Then there's the issue of the CRD. Blake claims she amended it, but that's where a massive problem pops up. There's a glaring flaw in her filing, and Kevin barely even touches it because he doesn't need to. Under federal law, if you want to sue under Title VII, you are absolutely required to have an EEOC right to sue notice. Blake's complaint, it doesn't include a single CRD document. Not one. For her lawsuit to stand, her complaint should have clearly stated the date she filed with the California Civil Rights Department to prove it was timely. It should have attached a copy of that filing so the judge could verify whether the individuals listed on the right to sue notice were the same ones she was dragging into this lawsuit. She didn't do either of those things. In her first complaint, which dates back to December 20th, 2024, she tried to rope an It Ends With Us movie, but without any right to sue documentation attached to it. She never attached a CRD complaint copy, and she didn't include a federal right to sue notice either. And here's the catch. You can't fix that kind of error after the fact unless you notify the court and formally request permission to amend your complaint to add those parties. She didn't do that. Instead, she improperly included It Ends With Us right from the start. And now, changing things around doesn't erase the fact that she failed to properly exhaust her administrative remedies in the first place. That's straight from the CRD rules. So Kevin makes the point clear to the court. A judgment on the pleadings is appropriate when the opposing party fails to allege enough facts that could possibly give rise to a legitimate claim or defense, even when you read the complaint in the most favorable light toward them. And in this case, Wayfarer's motion isn't about complex evidence or discovery battles. It's about legal issues that are clear from the face of Blake's own complaint. The Wayfarer team is very clear. The legal issues at stake here include Blake Lively's claims of sexual harassment, retaliation, failure to supervise, and aiding and abetting under California law. According to them, all of these claims fail because California statutes don't have extraterritorial application. Here's what that means in plain English. If you go through the California Civil Rights Department, CRD, you'll get a letter called a right to sue notice. That letter gives you permission to sue under California law, but only in the state of California. If you want to bring federal claims in California federal court, you need a separate federal right to sue letter. Blake's CRD letter never gave her the green light to bring California-based claims in New York. In her motion, Blake tries to argue that her federal claims justify being in New York and that her California claims are related because they come from the same alleged conduct. Therefore, she says, the New York court should have jurisdiction over all of it. But Wayfarer points out that this isn't enough of an argument to establish jurisdiction. They also emphasize that she failed to properly exhaust her administrative remedies when it came to her claims against It Ends With Us movie. On top of that, she didn't adequately allege retaliation, her defamation claims are barred by litigation privileges or fair reporting protections, and she failed to show an underlying tort to support her civil conspiracy claims. What's important here is that none of these issues require the court to look at mountains of evidence or ongoing discovery. Every single one of them can be determined by simply reviewing Blake's second amended complaint and the documents she attached or referenced. She hasn't explained how any of her so-called evidence would even apply here, or why it would be relevant to denying the motion. Put simply, there's no need for Blake to scramble to collect discovery evidence to oppose this motion. The motion is about defects in her own pleadings, not about what she might hope to uncover later. Kevin Fritz makes another point crystal clear. Even though Blake hints that she might amend her pleadings again, she hasn't said why she hasn't done it already, or why the court should allow her to do so at this point. She's already had multiple chances. First, she filed her original complaint. Then she filed her first amended complaint. And finally, her second amended complaint. That's 3 shots already. The rules don't allow her to keep endlessly revising her claims until something sticks. And even if she were allowed yet another amendment, it still wouldn't change one unavoidable fact. Her FVA claims can't be brought in federal court in New York. She's simply in the wrong venue. If the judge grants the motion in full, or even partially, it will immediately reduce the number of claims Blake can pursue. That, in turn, would streamline the case significantly. Even if summary judgment motions are filed later, there would be fewer claims to brief, fewer issues to submit evidence on, and less overall work for the court. And that's exactly the purpose of a Rule 12(c) motion, to narrow the case and preserve judicial resources before unnecessary litigation drags on. In fact, Kevin points out that if the judge rules now on the pleadings, there may not even be a need for summary judgment later. That's how powerful and efficient this kind of motion can be. He also dismantles Blake's argument that this motion will somehow delay her trial date, which is scheduled for March 2026. He reminds the court that fact discovery is still ongoing, no summary judgment motions have even been filed yet, and the trial is still more than 5 months away. He even gives examples of other cases where judges granted Rule 12(c) motions much later in the litigation process, sometimes even after summary judgment motions were filed, and in some cases, after partial summary judgment had already been granted. So the timing argument doesn't hold water. And here's the part that makes it almost ironic. Blake is now asking for an extension of time because she says she's too busy with discovery. But let's not forget how many times she and her husband have filed motions for sanctions and other filings against Wayfarer and their attorneys, all while discovery was happening. Wayfarer had to respond to those motions while juggling discovery, but Blake refused to grant them extensions when they asked. Now she's turning around and claiming she doesn't have time to respond. Kevin calls that out directly, pointing out the hypocrisy. He also warns the judge that granting Blake's request would only create procedural chaos. If she gets more time, the parties would end up briefing this motion right up against the summary judgment deadline before the court has had a chance to narrow the case. That would undermine the very purpose of streamlining. Then Kevin brings up another issue. Blake is asking to amend the case management plan and scheduling order. But he explains that this is inconsistent with what the court already laid out. Back on September 9th, the judge revised the scheduling order, extending expert discovery until November 14th. But neither the parties nor the court ever agreed to push back the November 5th, 2025 deadline for summary judgment. The order still stands. The rule is simple. Summary judgment is supposed to happen after discovery is completed. You don't file it while you're still in the middle of discovery. And right now, fact discovery isn't even scheduled to finish until October 10th. Kevin also tells the court that just last night, Wayfarer submitted a proposed revision to the case management plan and scheduling order. They're waiting on Blake's response. In their proposal, they outlined clear dates. Opening expert reports would be due October 24th, and rebuttal reports would be exchanged by November 7th. The deadlines that have now been laid out are pretty specific. Depositions of expert witnesses must be wrapped up between December 1st and December 15th, 2025, and the final deadline to file summary judgment motions will land right after that. The Wayfarer team argues that there's good cause to stick to this revised timeline because it serves several important purposes. First, it gives the court the breathing room it needs to carefully evaluate the pending motions. Second, it allows both sides to actually complete fact discovery before exchanging their expert reports. And third, it ensures that expert discovery itself is finalized before the summary judgment stage. Here's why this matters. If the judge agrees with Wayfarer's motion and dismisses the majority of Blake Lively's claims, this schedule gives both the parties and the court the chance to focus on only a few remaining claims when summary judgment or trial arrives. That makes everything more efficient. Now, here's another twist. On September 30th, just 10 days before the October 10th deadline for opening expert reports, Blake suddenly introduced an entirely new theory of damages, what she's calling her lost profits computation. In other words, she changed her damages calculation at the very last minute. Wayfarer points out that because of this surprise shift, their experts need more time to analyze her updated claim. Honestly, that makes perfect sense. If the trial date in March 2026 isn't being moved, then why wouldn't this adjustment be considered reasonable? And like I've said before, you simply cannot file for summary judgment while discovery is still open. It's procedural common sense. So, in reality, the only reason I can think of for Blake to resist this revised schedule is purely strategic, because from a fairness standpoint, this timeline benefits everyone involved, including her side. Now let's get into something that's both serious and, frankly, a little bit hilarious. We're talking about requests for admission. Before summary judgment or trial, both sides are required to narrow down the factual disputes by admitting certain uncontested facts. The rules are very clear about this. According to Kevin Fritz, the deadline to serve these requests was August 14th. Yet in the joint request to revise the scheduling order, Blake's team never asked to extend that deadline, and no court order was ever entered granting more time. What happened? Months went by. 6 whole weeks after the deadline passed, Blake suddenly tried to extend it, but without any explanation as to why she didn't serve the requests on time in the first place. She also failed to explain why upcoming depositions prevented her from doing so, especially since the entire purpose of requests for admission is to streamline the case before trial. Kevin argues, and rightly so, that this kind of negligence doesn't show good cause. So he asked the court to flat out deny her attempt to revive the missed deadline. And honestly, it is wild. Think about how many times Blake has rushed to court accusing Wayfarer of being late, of stonewalling, of not handing over documents quickly enough. Yet here we are, finding out that she herself missed the August 14th deadline for requests to admit, and only after the fact is she seeking relief. The irony is almost too much. Kevin even questions whether Blake's legal team truly has control of their client, or if they're even being straight with her. Because at the end of the day, no experienced attorney in employment litigation would ever file a case like this without the proper federal right to sue notice attached. And here's the kicker. Blake Lively still has not provided the court with a single letter proving she even has the right to sue. All Wayfarer really has to do is show the judge that when Blake first filed her lawsuit, the It Ends With Us movie wasn't included in her right to sue notice. And once you file a lawsuit based on that notice, that's it. That's your one opportunity. You can't amend later and simply add new parties retroactively. That doesn't cure the defect. If she truly got a new right to sue letter later on, the law requires her to notify both the court and Wayfarer. She didn't, which is exactly why Wayfarer is brushing off that argument entirely. And honestly, I've been saying this from the start. These claims were essentially dead on arrival the moment Blake filed them. She completely botched the steps with the CRD and the EOC. The bigger question is, when will the EEOC issue come to the surface in court? Because as of now, there's no evidence Blake has even received a federal right to sue letter from the EOC. Here's why that matters. Her California letter explicitly told her she needed to file a charge with the EOC herself if she wanted to go federal. It gave her two options. Either go within 30 days of receiving that letter, or within 300 days of the last alleged incident of harassment. Blake didn't file a dual complaint or a cross-filing. She just didn't do it. Why? Because she knew she was already out of time. She claims the last incident happened in May 2023. By the time August 2024 rolled around, the 300-day window had long since passed. So, she's been time-barred from the very beginning. And now she's upset because Wayfarer is pointing that out and finally moving to shut her case down. Even if Wayfarer had strategically waited, they were fully entitled to. They had every right to file this motion after her second amended complaint, because by then, the time bar was undeniable. Blake herself chose to amend, and that gave Wayfarer the perfect opening. So at the end of the day, these procedural messes are all self-inflicted wounds. That's the bottom line. Every single issue she's now crying about comes from her own choices. She filed the second amended complaint, knowing Wayfarer would respond. She knew they might file this motion. She knew the risks, and yet she's now trying to spin it as if she's the victim of unfair tactics. I just hope the judge sees this clearly and doesn't let the noise overshadow the facts. There's actually a hearing scheduled on this exact issue tomorrow. I'll be tuning in, and once it's finished, I'll give you all the details. I don't expect the judge to rule immediately. He'll probably take it under advisement, but as soon as there's news, you'll hear it from me. So, let me know what you think in the comments. Do you believe Blake's case ever stood a chance? Or was it doomed from the start because of these massive procedural mistakes? Don't forget to give this video a thumbs up. Hit that subscribe button if you haven't already, and tap the bell so you never miss any of my updates on the Blake lively lawsuit drama. Thanks for sticking with me until the end. Bye, besties.